Okay, that's the prosecution's opening statement in Van Dyke. Again, a second-degree conviction for him, police officer going to state prison. Let me bring in my awesome crew that I have, and we got more coming later on. With me in studio, my good friend, Mike Koribanics from the Koribanics Law Firm. Mike, welcome.
Bob, thanks for having me.
Yeah, absolutely. Mike and myself, we're baby prosecutors together in Hudson County, New Jersey. Mike is one of 250 certified criminal trial lawyers out of 98,000 lawyers in the state of New Jersey. I happen to be a certified guy too, so we're very proud of that distinction. Great to have you, Mike. And I also want to bring my man, hashtag 4041, shot a 40-point game, 41-point game when he was in high school, but more importantly, DOJ, for 3 decades, a prolific trial record of over 100 trials, in addition to the fact that they actually, at the DOJ, named the room. I'm really impressed by this, Gene, because to name the room the Gene Rossi War Room really tells me, you don't have to tell me you're the real deal, but shows that all the respect you got. Welcome back, Gene.
But I'm not certified in New Jersey.
Well, we'll have to rectify that. We got to start trying some cases together, me and you. And then we have the chief of police in Denville, New Jersey, Chris Wagner, with us. He's been the chief there for 11 years, 30 years as a police officer. He was the president of the New Jersey State Association of Chiefs of Police. He's a graduate of the West Point Command and Leadership course, as well as the FBI Law Enforcement Executive Development course, and he is a New Jersey certified police instructor and happened to be one of the chiefs of police under my jurisdiction when I was the county prosecutor. Welcome, Chief Wagner.
Pleasure to be with you today, Bob. Thank you.
Okay, awesome. Chief, let me start with you a little bit, because we often talk about law a lot, but me and you actually were involved in a police-related shooting fatality. I was investigating it as the prosecutor. When you found out about that when you were the chief, tell me what goes through your mind and your concerns initially as a police chief in charge of being involved in that kind of incident.
You know, it's pretty amazing the things that we have to think about. And I had only been the chief for 7 months, and I think you weren't the prosecutor in Morris County much longer than that. So we really didn't have an opportunity to interact. And there's so much that goes through your mind. The first and foremost concern is your police officer. You know, are they okay? Did they survive? Were they injured? The victim who was shot, there's a compassionate part to the police where we're really concerned about the victim, you know, and what took place, and then every member of your police department. And then sometimes what's forgotten is the family of the police officer that's involved. I can tell you that in some cases, it was harder for me to deal with the police officer that was involved in the shooting's family than it was dealing with the police department and the police officer himself. There are policies and training and memos and reporting and courtroom testimony that you have to consider. It becomes completely consuming for your life as the chief of police, and especially for the police officer that was involved in the deadly use of force.
Yeah, and I know that there was some some tension there too when you have a prosecutor's office kind of swooping in there, as I did, at the crime scene and taking over the investigation and kind of losing control of that piece.
Right. So you know, we're problem solvers by nature. That's what we like to do. We like to move in and solve problems, and it's generally, in almost every case, it's our job to often work in partnership with the prosecutor's office on significant events. But on a case like this, and we've determined that it's rightfully so that there should be an independent investigation by someone other than the police department, and that was your job as the prosecutor. But it is uncomfortable because here's a very significant event that just occurred, and my drive and desire is I want to protect the police officers that work for me, and I want to know what happened and get out in front of it right away. But there's a lot of information that we're not allowed to know and we can't share, and it is uncomfortable. But over time, and I think we're going to talk about this today, that with a trusting relationship and fairness and honesty, everybody can come out fine.
Okay, excellent, Chief. Mike, let me flip to you real quick. You do a lot of criminal defense, and you represent police officers. In fact, I think you're even on the PBA list in New Jersey as one of their go-to lawyers. What do you do when you have a case like this? Now, these cops that are going on trial on Monday are alleged to have basically falsified reports and tried to make it more favorable to Van Dyke by saying that the victim was more threatening than what the video really shows. What's your approach to this at trial?
Well, a trial from the defense point of view, I mean, this is really like, you know, manna from heaven for a defense attorney when you have police officers that are accused of falsifying reports. It's evolved a lot more, Bob, since when we first started this, is Now, of course, with exculpatory evidence rules, and the police officer who gets found to have falsified a police in today's day and age, his career is done.
Yeah.
Under the Brady cases, his career is done.
Yeah. And I'm sorry, Mike. And Gene, you know, in New Jersey, I was actually on the commission from the Attorney General as one of the prosecutors to go over the Attorney General guidelines. And one thing that we really worked heavily on is that if an officer is found to have lied in a report or falsified anything, that is tagged on them for the rest of their career and is to be produced to the defense, which essentially could eliminate that officer from ever being effective because testifying is an essential part of being an officer. What are your thoughts?
Oh, Jesus. In the U.S. Attorney's Office in the District of Columbia and in the Eastern District of Virginia, we had a list of officers from all the agencies who had what I called giglio problems. They lied under oath, gave misleading testimony, they made false reports. And here's the problem with those officers. If you have a very serious crime like rape, murder, or violent drug trafficking, it could affect the charges you bring, right, because you can't use that witness because of their giglio credibility problems.
Right. I mean, I confronted this myself. The witness becomes essentially ineffective. If they wind up involved in a homicide case, a gang investigation, drugs, the defense is going to have that data and information and say, you've lied before and now you're lying. Chief, real quick, one quick question, 15 to 20 seconds. Why would it be that in today's day and age with MVRs, motor vehicle recordings, and body cams, that officers would even think about falsifying testimony when there were so many cops out there at the scene and that tape was going to clearly belie the information they're putting in the reports? Why is that?
You know, I have a difficult time answering that question. I looked, you know, at some of the documents today that's been presented in front of the court, and I can only believe that in a couple of split seconds, those police officers made a decision or observed some things, and then either hours or days or even weeks and months later were asked to recall that information and may have recalled it improperly, may have gotten some bad advice from a supervisor. I really got to believe in my heart of hearts that those police officers didn't choose to sit down and concoct a story that would be contrary to what was seen on this videotape. You know, they're talking about seconds, a second and 1 second and another second, and the information that they had to process is enormous. So I really can't answer the question. I wasn't there, but I got to believe that they didn't choose to make up you know, a bad story to cover.
Okay, well, I am fortunate enough because the producers at the Law&Crime Network are awesome. They have actually gotten some filings in Cook County on this case with regard to some of what the state alleges are significant misrepresentations that led to the obstruction and conspiracy charges in this case. We'll go through that a little bit more, but we're going to go to a break. We'll be back on the other end. Don't go anywhere. Great job. All right, that was the defense attorney in the Van Dyke case, and we know that that didn't turn out well. The defense in that case went down on everything. And listen, I'm busted. I love you guys in the chat room. You make me laugh. Do I think that Van Dyke is going to testify? The answer to that is no. Van Dyke has a Fifth Amendment right still. He has not been sentenced, so that's not going to happen, at least unless he wants to, which I doubt anyone, given the testimony that he gave during his own trial, would ever consider him as a viable witness. I think he killed himself. And fight for TA on the question about prison. Stay tuned. We are going to have a prison expert, somebody who actually spent time in state prison and now consults people about state prison about what Officer Van Dyke or former Officer Van Dyke's life is going to look like inside a jail. But Gene Rossi, let me go to you real quick. In this case, based on the filings produced by in the court that we got here at the Law&Crime Network, they are very specific, the prosecutors, that they wrote that he was actually attacking them with a weapon, and that even after he was shot and he was on the ground and still armed with a knife, that he ignored their commands and was raising his arm towards them in an attacking fashion, and on the pleadings go, including, I believe, two police officer witnesses who were going to say that they were being prevailed upon to falsify their reports. You're a defense guy now. You're a prosecutor. What are your thoughts about how you get around all that?
With the utmost respect to the chief, that's very bad for two reasons. It's not just, you know, I thought it was 3 seconds. It was actually 4 seconds. It's like the sky is blue versus the sky is dark. And the other thing is, when you have evidence that police officers are asked to write false reports, that's horrible for the defendant. Horrible.
Yeah, and of course, I know that the chief didn't have these pleadings. I have them right now. And Chief, I think a lot of this comes down to, you know, when we've handled lots of cases together, in the county I was in, there were 39 police agencies, you being one of them, and there were 39 different temperatures, 44 law enforcement agencies in all, 39 municipalities. And there seems to me from the top down to be something that's very significant with regard to whether cops feel that they've got to write these kind of reports in order to cover their fellow officers. Do you agree with that based on your career, that this is a leadership issue in terms of what is expected of them?
Yeah, I mean, I couldn't agree more that it's got to be from the top down, and it's got to be crystal clear. You know, you've got to, I've been in this business 31 years, and, you know, I learned in the beginning that, you know, when you walked outside of your car and you checked your car, you know, it said you could write down how much oxygen you had in your car yesterday. You didn't really have to check it today. And we know that today, you just can't do things like that. You either did it or you didn't. You check the box or you don't check the box. And you know, the idea that these guys falsified records on a deadly force case is just, it's unfathomable to me. It really is. But I would agree. It's from the chief to the captain to the sergeants down to those rank and file police officers. There's got to be somebody watching, and there's got to be somebody teaching and training to say, this is the only acceptable way to write this report.
Excuse me for interrupting you, Chief. There you see this video right here of him walking away from the officer. I just read, but the accounts are he's spinning and going down. Continued shots, as you see right there. Nothing is consistent with what was put in these police reports. Mike, excuse me, Chief Mike, when you're defending a guy, look, you know, I'm not saying you can't justify it. I was very hard on all. You lied in a report, you were gone. If you know, you get a non-prosecution agreement, maybe. If it was really bad and somebody got arrested or somebody got injured, it was going to be worse. Your career is over at a minimum. What do you do to try to negotiate on behalf of an officer facing this, short of going to trial?
Well, you know, Bob, that's the point that's well taken here is, you know, trial's the last resort in a case like this. I mean, you've got to look at the cards that you're being dealt. The facts here are pretty overwhelming, and that presents such a huge problem for an attorney when you're defending these defendants. And if you really can't get them to see what light is coming through and the truth, then you've got no choice but to go to trial. And that's a horrible position to be in, especially in this case, because, you know, there's a saying, facts are stubborn. Mm-hmm. Those writings do not change. They have to live with those throughout. And boy, I think jurors get really disgusted when they see that the people they entrust their safety to have no hesitation to lie when a young man's life is lost, and that's a problem.
Yeah. Gene, you know, you were a line guy for the DOJ for a lot of years. You're a law guy. You know, when you're in a position where you have to make the command decision, Gene, to either push the button on these cops or not, there are some cases you might and some cases you might not. In your mind, was this the kind of case that you'd go to the hoop with? No pun intended there, hashtag 4041. Is this the kind of case that you would really want to send a message and not really offer a lenient plea offer because you want it to be known that this stops now, and if it doesn't, you will go to jail too?
Absolutely. And I love Chief Wagner. I love all the chiefs of police because I dealt with a lot of them. I got to say, if I had this case, I not only would have taken it to the hoop, I would have done a LeBron James dunk. And I would have said, I would have sent a message to all the chiefs of police and the underlings that, you know what, this is an outlier, and we have to protect the integrity. We have to protect the integrity of the police. And the only way to do that is to send a message that his conduct and the conduct of others is so outrageous that we can't tolerate it. Bob, I even indicted a prosecutor. So I take it very seriously. And I would have sent a message big time.
You know, there's also a collateral consequence to this there, Gene and Mike and Chief, and that is the jurors will not believe the prosecution and police officers' cases if there is not accountability. It is so important, and I like to think, as my last point, that is when I was prosecutor, I tried to explain to them that these rules and that we're going to follow to a T are there to save you from what is happening to Jason Van Dyke and these three other guys. We got to go to break. We'll be right back. Okay, so That officer's testifying in Van Dyke, and I expect that that testimony will, Gene Rossi, come out also during the next phase of this case on Monday with the 3 officers accused of falsifying the reports. Gene, my suspicion is he gets called to testify to say that they did not see a threat. He wasn't saying anything. So if that is true, then how is it that all of these misstatements were made in numerous police reports? What are your thoughts?
If there's no threat other than he's holding a knife, which some could argue that itself is a threat, but there's no threat, there are no words, and the reports show that there was a threat, there was words or actions, you got night and day. There's no gray area. That's very bad.
Chief Wagner, I'm curious. Now, when I went through the firearms training, the PTC, Police Training Commission certification course, they had on the FATS machine, I think it was called, a scenario with a person with a knife standing next to another person, and they had 2 alternatives in that machine. One is you shoot and the guy is dropping the knife, listening to officer commands, and another one is that he actually stabs the person. But we don't have that here in this case. As you could see in the video that we're showing right now, he's walking down the center line, and I think this is an important fact. And the officers are out there. You listen to tests. He's now veering off the line. And no officers have shot. They've just been trying to redirect them. And then here comes Van Dyke. Boom. And there goes 16 rounds into the guy. I mean, is there any way that as a chief of police, when you're reviewing this tape, should you have been given the opportunity to, would you be saying, yikes, this is bad, there's no justification for it, or would you still want to know more?
You know, I think it's really important to be in the mind of the police officer. I think that the prosecutors and the defense attorneys will even tell you it's important to know what's going through the mind of a reasonable police officer at the time he chooses to use deadly force. And I think that's critically important. And I wasn't there. I'm, you know, hundreds and thousands of miles away from Chicago. So I have a difficult time second guessing them. It doesn't look good on the video. I can't lie to you. The fact that the shots continue are disturbing to me. It's a disturbing video to watch. But, you know, we have the pleasure of watching this. I think we're 3 or 4 years out now, and we've just watched it, you know, 10 times just today in this short presentation. You know, the officers have a few seconds to determine where that individual is going to go with that knife, and he's been around some people in a public place, so it's hard to determine where they're going to go and what they're going to do.
Chief, we just saw a sign somebody held up there, 16 shots, and this is definitely a clarion call for the prosecution. 16, 16, 16. In 15 seconds or less, can you give me an idea, is there a standard amount of shots that you're trained in, or is it just until the threat is neutralized?
So the standard language is you shoot to take away the threat. That's the standard language. There is absolutely no standard for the number of shots fired. In one of the cases that you and I investigated, one of my police officers fired, I think, 26 rounds from an AR-15 rifle, and it was justified. So there is no standard number. It's what that officer feels he needs to do to take away the threat and make sure that the person's not threatening again.
Okay, Mike, listen, as a defense guy now, I think that the defense of Jason Van Dyke could have been, if I were a defense guy, I'd rather represent him and think I'd have an easier chance with him than I do these 3 cops that are going on there for falsification of the reports. I think it's actually easier to defend Van, and I'm not saying justify his actions. I think there were more defenses available for him to at least make an argument. What are you doing with these 3 cops going on for falsification of reports?
Well, the first thing is I tend to agree with you. I mean, as the chief pointed out, you know, we have here a video which only takes a moment in time. It doesn't give us the whole picture. There has been studies that have been published, I've read of them in the New York Times, where, you know, a turning with a police officer on the scene, that the mind sometimes goes ahead of you and your training lets you see things ahead that aren't actually occurring. Things of that nature are defensible, and I'm surprised they never brought that type of expert into this case. Yeah. The problem with the 3 officers is that they had time to reflect before they put pen to paper on this matter. And that's where you're really going into such a high level of an intentional crime, and where the official misconduct in Illinois comes into place, because that statute says that the law enforcement officer has to intentionally produce facts that may not be accurate, which is sort of ironic because facts are facts and should be accurate, but that impede the investigation. Clearly, the intention of these 3 officers, according to this complaint, was to impede the investigation of a fellow officer so he would not be held criminally accountable. And you know, that really, I'm surprised, it really shows a consciousness of guilt, not only as to these three, but as to Van Dyke as well, because there felt there was a need of something to cover up.
Well, Smile on NE, I see what you're writing here. You liked what Chief Wagner said. The video doesn't show everything, and I certainly don't disagree with that. However, I think Mike is making a good point here, guys, that, and our chatters seem to agree with it, that it's easier to perhaps defend somebody who made a split-second decision like you and the chief are saying, as opposed to somebody who intentionally manipulates, has time to deliberate, and manufactures evidence, and that's why they're going to trial. We got to go to break. Stay tuned. Don't go anywhere. Get in that chat room. Ask me some more questions. We'll be right back. Okay, so this is the tee-up. Gene Rossi, let me ask you a question. One of our chatters asked an interesting question in my mind. Fight for TA asks, and I quote, if a law officer has all the training, shouldn't the argument be more recognized for premeditation? This is referring to Van Dyke. We see in first-degree murder trials all the time that premeditation can only take a second or seconds, which is a true assessment of the law. This officer wasn't eliminating a threat, he was out to kill. So I guess the basic question is, can you use their training to show that this was not a split-second decision where they just lost their cool? The training is to eliminate that, so this goes more towards premeditation.
Yes, this is not his first rodeo. He has experience, he has training. He should know the parameters of when he can shoot and when, and how many shots he needs. And the chief brought up the point, you can take as many shots as necessary. Here, no shot was necessary, let alone 16. So that blogger's absolutely right. The training can be used against the defendant.
Well, let's go to a point that a couple have mentioned, and specifically Sunny Day in the chat room. Another excellent question, guys. Keep them coming. It gives me the opportunity to ask these guys some great questions. Chief Wagner, the taser issue. Now, I know when I was prosecutor that it was the beginning of the debate as to whether there should be tasers or not. I think people really find it interesting, the competing interests about this, because in this case, they were waiting for the taser to come. Everyone wasn't authorized to have a taser. What are your thoughts about the taser? Because it's always been shocking to me the level of cops not actually liking it or wanting something less than lethal force.
Only been permitted to use the taser most recently for incidents less than lethal, where something less than deadly force was necessary. So certainly a great tool in law enforcement. It looks like had there been a police officer there, it may have been an option to use instead of using deadly force. You know, a taser, like any weapon, is not an absolute guarantee. It may not function on somebody. They might miss, just like a police officer might miss with a firearm. So I would offer that every police officer should use every tool that they have at their availability, and where likely or where available, they should use less lethal force. But, you know, they're talking about they were waiting. Like, how long do you wait? You know, before they run in, he was in a Burger King, he was in a Dunkin' Donuts. How long do you wait?
This is what's confounding to me, Mike. I mean, in this debate that goes on about the less than lethal use of force via a taser, there are arguments about having it. But isn't it ludicrous to you that they're actually saying, you know, call in the taser during an unfolding incident?
Well, it's tough to fathom, like, what's going on here, because it just doesn't seem that anything ever comes to fruition where it has to get violence. I mean, they're watching him at a Burger King. They're watching him walk down the street. I mean, that video in those clips show he's really not threatening. Although one can argue that time when he turns with a shiny object could be the point where Van Dyke really just went into automatic mode.
Right. Well, guys, listen, I love your commentary. Thank you so much, guys, in the chat room. I really appreciate all your questions. They're excellent. Please keep them coming. We're doing the breakdown of this Van Dyke trial in anticipation for the new trial. Got to go to break. We'll be right back. I heard all these things over the radio. I made a split-second decision, like Chief Wagner is saying, and I'm sorry. 16 shots, 5 shots, I had to neutralize the threat. Something like that?
Yes, because he faced so many counts. I call these spaghetti indictments. You take a bowl of pasta, you throw it at the wall, you hope one sticks. If you give up a few counts, you gain credibility. And I want to go back to to Van Dyke's testimony. I thought the opening by the defense attorney was an A+. I really liked it. And I don't know if he did the direct exam of Van Dyke, but as you and I recall, Bob, when Van Dyke got on the stand, either he had been prepared a lot by the defense attorney and he just flopped, or he wasn't prepared and he still flopped. He was absolutely horrible as a witness.
You know, Gene, I felt when looking at his testimony that he was like searching in his, there's a picture of him right now. He's like got that dumbfounded look on his face throughout all of his testimony because he was trying to think of what he said before. He's trying to listen to the instructions of his lawyer. He's trying to make a good appearance before the jury. And I think that conflation of all of those things, but you should know that as a defense lawyer when you're going on what kind of witness. And who knows, the defense may have said to him, don't take the stand, and he insisted. We just don't know that. But Gene Rossi, one last thing I got to say to you is no self-respecting Italian would ever throw the spaghetti against the wall. We're going to break. We'll be right back. Okay, so that's the use of force expert for the state in the Van Dyke trial. Gene Rossi, explain to our audience what an expert is, what they're allowed to testify to, and what you thought the relevance of that was for the prosecutor. Because some may ask, well, doesn't the tape speak for itself?
You still have to, Bob, you still have to get into the mind of Jason Van Dyke. And by having this expert testify, and an expert can only testify on an issue at trial, and the mind of the defendant is definitely at issue. And the expert has to have basic training to qualify, and they also have to make conclusions based on scientific data, peer review. He clearly falls within that. What benefit does this expert have for the prosecution? It is profound. He's basically saying after the victim fell, there was no need to shoot. And 12 seconds, and God knows how many bullets transpired after he fell. That's devastating for the defendant. And he's a good expert.
Chief Wagner, yeah, excellent points, Gene. Chief Wagner, let me ask you, do you find that expert testimony vis-a-vis the idea that he couldn't shoot or didn't need to shoot this 16 times compelling? Or could you make an argument as an officer, I'm not saying that you make an argument in this case, that the 16 shots, consistent with what we said before, is what he felt was needed to neutralize the threat?
Yeah, so maybe not speaking specifically to this, that testimony in this case, but I think you can argue that the number of shots that you fire are always going to be dictated by the current situation. You know, we had an FBI instructor on our range last year that said, as you begin to shoot, you continue to shoot until the person falls to the ground and the threat's been taken away and neutralized. That was their training position to us at the range. Now, you know, you couple that with other training that you had. Listen, I don't like watching on that video the fact that it's whatever it was, 10 or 12 seconds, and a round or two later. That's most disturbing, and I think that may have been most problematic, or one of the most problematic parts of this case. But again, not inside of his brain and not standing 10 feet from the suspect holding a knife.
Well, let's be honest. Let me just throw it back to you one more time. Mm-hmm. We don't believe Jason Van Dyke woke up that day and said, let me go shoot somebody, okay? Is there something about, even though they're trained, even though they're supposed to perform under stressed circumstances, is there something about firing that first round in your training experience, your career, talking with your colleagues, that, and you're nervous and you're scared or whatever, that you just keep firing? I mean, it doesn't justify it, but is there something there, a piece like that?
So, what little experience I've had talking to people who have actually fired deadly shots is that first trigger pull is really I'm not even sure what the word is to you. It's dynamic, right? It takes a lot of thought to go into it. And then once you've fired once, you know, we've taught them that if you've been justified to shoot once, there is no number on how many you can shoot. And if it takes 10 or 12 or 16 or 26, then that's how many rounds you should fire. And then the caveat to that is so long as you can later justify that as a reasonable police officer. And, you know, maybe it sounds like the defense didn't do a good job of justifying that.
Well,
in this
Chief,
case.
they may not have done a good job, but let me tell you the good job they do here at the Law and Crime Network. Right in the middle of the answer you gave, they pulled up the ballistics expert that testified and thought that, based on what you just said, we should watch the clip. Let's take a look. Okay, so there's the state's expert FBI agent testifying about ballistics. Gene Rossi, this is one of your guys. This is one of the guys that you'd be calling when you were there at the DOJ for 3 decades if you had a gun case. And clearly what's being said here is he's referring to the flinching with respect to the victim. I just wanted to make sure that was clarified. I think he's trying to block the idea that the defendant, that the victim rather, was spinning around towards the defendant, Jason Van Dyke. Thoughts?
Oh, geez. I mean, the ballistic expert basically corroborates what you see with your eyes. And your eyes see a man falling to the ground, and he's basically almost dead after the first shot. And the ballistic expert is just adding more emphasis to what the eyes are telling the viewer.
Right. Chief Wagner, you're taking another look at this video right now, if you could see it. We keep playing it over and over again. These are the critical moments, hands down by the waistband. His right arm is moving to the side. You know, I've always wondered, you know, I think, let's go to the shooting case that we handled, right?
Right.
And I very vividly remember that the police officer in that case was unable to really even give an account of everything that happened. And but for the grace of God and the MVRs and the body cam footage that we had, we were able to put it together. But is it possible that he saw that spinning hands down by the waistband, and then they go into that cover-up mode, and so they start manufacturing things that he may have had a, how do I put this? I've seen cops, when I prepared them to testify, who can't articulate the essence of the thing. Is that something in your experience you've seen? They can't articulate it. They can't get it out right, what was going through their head.
Right. So, you know, I was watching this today with my captain here this morning, and we were talking about the testimony of Officer Van Dyke, and we said, you know, you better hope that your first time on a witness stand is not when you're looking down a couple of second-degree murder charges and you're fighting for your life, because it kind of looked like what he was doing there. You know, again, I can't understand what may have happened here. In our case, you know, if our police officer in Denville didn't have that dash camera and you explained to me what we thought had happened, I don't know that I would have believed the description if not for that dash cam video. So, you know, you know, the officer Van Dyke talks about the movement of the hand. I can see that briefly in the video. Again, we're not in the position he was in. We're not as close. But I guess it could be. You would probably know better than me from, you know, witness testimony what might happen in a witness's mind when they're fighting for their life. You know, if they're like, well, maybe if I say this, it might be better, and it just turns out to be bad. Yeah,
I found out in the course of affairs that human nature and memory and things like this are very, very tricky things. And that's why we try to have a trial, so that we can get to the truth. We are going to take a quick break. We'll be back on the other end. Okay, so that's the use of force expert for the state that's being cross-examined by the defense attorney. I think we heard some pretty interesting testimony there, Gene Rossi, consistent with what Chief Wagner had said. I believe the distance was 30 feet that you can close the gap. This guy is saying that based on the facts of this case, they were 21 feet and that it does represent a danger and you can close the gap. I think that's good testimony for the defense. He did a nice job getting that on cross. Why do you think that that was not made more of during the rest of the trial and the jury discounted that?
I have no clue. And I would add this. Not only was it 21 feet and it could change in a heartbeat, literally, but this guy was on PCP, right, and that accelerates the 21 feet. So the 21 feet really is about 10 for someone who's high on drugs. And I didn't see that really coming out a lot during the trial. Of course, I didn't see everything, but they should have made more of that. That's their theory. Yeah,
and Mike, I agree with Gene. To me, the basic blocks of defending this case would be, if you were a defense attorney, you'd have to say, got up that day, like you said, with his wife, kissed his kids, blah, blah, blah. You do all that stuff, right? They get a call at a person that was involved in a violent encounter. This is how I'd be, presenting it. And he doesn't know what is going on and what's not going on. And then he's hearing that the vehicle was assaulted, if you will. He's hearing that the tire was punctured. He's out at the scene. He smells it. He sees it. He tastes it. It's not a video. A video can't do all that for you, okay? You know that in real life. This would be my argument as a defense attorney. And when he's kind of walking away, and then he kind of turns, and he's got his hand down by his waistband, he could close that gap. You even heard the state's experts say at 21 feet, and that is what the officers are trained. And that's why he felt that he was in fear of his life. And maybe he fudged. We're going to get to your question in a minute. Maybe he made some mistakes in the manner. Maybe the police officers that supported his lies weren't right, but that doesn't mean he's guilty of second-degree murder. It's something less. Thoughts?
I agree with you. I mean, that's the argument you make as a defense counsel here, especially with the video. It doesn't say all, but it does say all in certain aspects that would help the defense. Number one is you have someone here, there are police cars. There's a camera coming up on him. There's a police car in front of this young man. There's police cars coming in the side. He sees that things are getting, basically the wagons are being surrounded around him, and he's not yielding to that.
He's not listening to officer commands. Right.
He's not predictable, and it's an unpredictable situation. He at one point really goes at the police car, then veers off. And all these things, I think, really needed to be played up a lot more in the defense and brought to the attention of outside the, like when the expert said, look at where the arrows are, that's where you should pay attention. I think the defense needed to point a little bit of the arrows to other places other than the shooting itself to show the surrounding situation.
Right. I like the word you use because I think it would resonate with the jury that it's unpredictable. He was acting unpredictably. He was erratic. He was on PCP. See, you don't know. That video doesn't show you the look, the stare, the failure to listen to officer commands. It can't tell you that, but he can because he's a human being. He's not a machine. He's not a piece of tape. Chief Wagner, this would be the argument that I would be making if I were defending the case. But do you find, I find, that a lot of people ask these questions about the officer-related shootings on motor vehicle stops and things of this nature. Training is a big part of this, and police officers are constantly trained, in my mind, that a motor vehicle stop is the #1 way, or motor vehicle encounters, the #1 way cops are not going to go home at night. And they're also being trained, which was admitted to by this state's expert, that, as you've indicated, they were 9 feet closer than the zone that the gap can be closed in. Do you find that testimony actually helpful to the defense?
Yeah, I do. You know, this is an armed encounter. It's not a traffic stop that you're walking up where you don't know who's inside the car, where they might have a gun or they might have a knife. This is an armed man within just outside of arm's reach of you. And, you know, we're watching this video, and unfortunately it ends with, you know, the victim falling to the ground. But what we don't know is how this video would have ended had it played out for 5 seconds or 10 seconds or 1 minute longer. How much more violent could this encounter have been? Could that suspect have lunged at the police officer? There's the knife right there. Imagine that inside your jugular vein of your neck if the guy closed the distance too fast. So we have the opportunity of today, 3 years later, looking at the end of the video, and it's a horrible ending. But what would have been had the officer not acted at that very moment? So the training and all that plays in.
Let me ask you real in 5 seconds or less. Gene Rossi, Mike Koribanics, I'll start with you. Mike, you're in studio. If it had been done differently, had this defense been raised and had a defendant not testified, could it have been potentially a not guilty?
I think it could have potentially been, yes.
How about you, Gene?
Hung jury.
Yeah.
That's what I was thinking, Gene.
Yeah, see, that's he got you on that. I think it would have led to a hung jury. I think the defendant killed himself and capped it. But listen, you guys are doing a great job. I really appreciate it. We got more to come on this case. Stay tuned. We're going to go to a break. We'll be back on the other end. All right, so Chris Wagner, what are your general thoughts about what we have been discussing? I know you're not a lawyer, but you're a cop. You've worked with lawyers. You've testified before. And I'm looking in the chat room, and Anon 3049 and other people are kind of indicating the same thing. And we're going to get to that guest in a minute, folks, so just hang in there for us. That a different defense strategy may have made a difference. Now, again, we don't like to be overly critical, but do you think that the testimony of the defendant could have really made a difference here, or if the arguments that you were bringing up about closing the gap and the 30-foot, and this was 21 feet, and the knife, and the violent actions before, and the PCP, and robbing the trucks and confronting somebody earlier, could have made a difference in terms of at least a hung juror, just 1 out of 12?
You know, I'm not a lawyer, but I've been in this game 31 years, and it does seem to me like there might have been some missing pieces that could have really swayed some people. Maybe a little bit more human emotion for people to have a real understanding of the split-second job that police officers do and the split-second decision-making that we have. The fact that, you know, we're watching this video today, you know, 3 years later, and we're talking about 1 or 2 seconds. You know, the district attorney out there talks about the police officer taking 1 step in one direction and the victim taking 1 step in one direction, like it's a big deal. You know, the victim took 1 step away from the police officer, and that's supposed to indicate that he was retreating.
Right.
I think you can defend against that and say, you know, 1 step, you know, that's not, the cop's getting out of his car. It's natural that he's going to take steps towards the area of the suspect. I do think that there were some things that could have been brought up that could have changed the outcome here.
Okay. Well, you know, again, like we had just indicated, Chief, we've worked cases together where people really didn't know what happened, and they're trying in their memory to cogitate a stressful scenario like that. We had a case exactly like that in a police-related shooting fatality. We got to go to break, and I promise you, my special guest, we're just teasing him, he's going to be coming on.